Okay, so in this lecture we're going to be covering remedies. This basically is where you've already had your claim, it's gone through successfully, and now we're looking at what's the best remedy for the claimant. It's very subjective, it's on the fact by fact basis of each case, and we're going to focus on damages, injunctions, and self-help remedies. The bulk of the lecture will be on damages, and I'd like to emphasize here that this is purely a revision lecture. I won't go through a lot of the content because it takes away from it being a brief revision lecture which you can quickly use to go over before an exam or just to cover your notes. I'll provide a document for one of the sections which will provide further detail, which I don't think is appropriate to go through in this lecture, but go through, I think, whatever book you're using. We're using Gilliker in our course at City. Go through the chapter for this because it goes in a lot more depth. Okay, so firstly we're going to be looking at compensatory damages. It's important to remember that you only have one chance to go to court for these damages, and the aim of these damages is basically to put the claimant in the position had they not suffered this loss, and that was established in Livingston. We can also look at Lim and Camden. In this case, there was a 36-year-old doctor. They underwent a minor operation and ended up with brain damage due to clinical negligence. They were barely conscious, they were totally dependent, and the doctors found it unclear as to what their recovery would be, when it would happen, if they'd ever completely recover, if there would be any recovery at all. So what the Court of Appeal decided to do was make interim payments until they could continue assessment and decide what would be best. However, the House of Lords said that this was unsound and that lump sums should be given to parties to return to their original positions. It seemed unfair and a bit long-winded to have these interim payments and keep going. It brings the cases back to the courts. It should more be one decision and that's done. We also have restitutionary damages. In these cases, they talk about unjust enrichment and they don't really focus on the claimant's loss anymore, but where the defendant has gained at the claimant's expense. Something similar is exemplary and punitive damages. So these focus on the defendant. It's basically looking at their conduct and punishing them for it. It's no longer focused on the damage suffered by the claimant. In Rooks, Lord Devlin restricted these into 3 different categories. So the first was oppressive, arbitrary, or unconstitutional actions by servants of the government. The second was conduct calculated to make profit in excess of any compensation payable. So this basically says they've looked at the situation, they've realised we may have to pay compensation, however, the profit that we're going to make off of this action is a lot higher. So that was similar in John and MGN. So this was where there was an article published about Elton John saying that he's on this diet where he bites and then spits out his food, he doesn't swallow it, and that he's suffering from a type of bulimia, which he actually was previously. And what the issue here was the fact that they made no attempts to verify this story. They published it for the purpose of profits, and so exemplary damages were applied here. And the third situation where you can use these is when authorised by statute. So we also have aggravated damages. This is also a type of compensatory damage, and it allows the potential for double recovery. So this basically occurs where the defendants acted in a way with malice in order to make the situation worse for the claimant. It causes them emotional or mental damage. And in Richardson and Thompson, they've basically said that these damages are awarded at the court's discretion and they usually tend to be in quite moderate amounts. Next we have nominal damages. So the courts recognise that the claimant's rights have been infringed, however, it doesn't seem that they've actually suffered any particular loss. So in Constantine, a cricket player went and asked for a hotel room. They were available, however, they refused to give him one as he was black. The court said that this was unjustifiable humiliation and it caused them distress, and so damages were to be awarded here. However, no actual loss had occurred. So they only gave away a token amount. It was 5 guineas, something like that. Very, very small. But it's the courts acknowledging that this right was infringed. The claimant does deserve something, and the defendant's actions were wrong. Next, we can look at contemptuous damages. These are basically where the claimant hasn't actually acted properly, or their actions may have been immoral. So these are usually awarded in defamation cases. An example of this is in Newspaper Groups Limited 2002 case. So here there was evidence to suggest that they were taking bribes, the claimant was taking bribes to throw games. They claim that they didn't. However, the courts asked why they were engaging in these conversations anyway. This claim only arose because they were talking and having these conversations. And it was held that yes, defamation had occurred, but the claimant was very dishonest and they also undermined the integrity of the game. And so the damages ended up being £1, and the defendant was asked to pay only 2/3 of their sums. So this is where I'm going to provide a document with more detail, much more depth. Basically, when there's personal injury, you break off into 2 forms of damages. So there's non-pecuniary losses. These are non-financial. So the courts have to look and see if this tort hadn't occurred, what would be the claimant's position now? So it's quite a subjective test. It looks at the claimant themselves, their lifestyle, and it also allows for compensation to be provided where there's been pain and suffering, because there's no physical loss, but emotionally there's a lot going on. You should still be compensated for having this occur. And also it looks at loss of amenity, so where the claimant isn't able to enjoy daily things that they would have done. So say if they were always going for walks in the park and they can't do this now because their leg's been amputated, it looks at these kind of things. There's also pecuniary loss. These are financial losses, so the fact that they can't work or that they have to go to a lower job, they won't be promoted. It also looks at the fact that they may not have lived as long as they would have, their life expectancy's gone down. And here they also take into account deductions. So if this certain amount of money it wouldn't have gone into your pocket anyway, they would reduce this from the damages that you're given. Next we can look at injunctions. Injunctions are basically just authoritative warnings and orders. They can be used to restrain actions or even compel certain acts to occur, such as making restitution to an injured party. Damages can be given in lieu of an injunction if the injury to the claimant's legal right is small, if it is capable of being estimated in terms of money, it can adequately be compensated for by a small payment, and if it would be oppressive to the defendant to grant an injunction. We also have self-help remedies. These are basically, you have to do something to find yourself a solution. However, there's a clear line here, and you have to do this within reason. In Revel, there was a farmer. He was very tired of people stealing from his shed. He decided to sit out with a shotgun and shoot at burglars, and it was held that this crossed this line. You have to act within reason, and when not done, your remedy is not accepted.